Yes, Ms. Norkai.
My Lords, I, together with my learned junior, Miss Moses, who sits behind me, appear on behalf of the appellant, Mr. Berger. My learned friends, Lord Folkes KC and Mr. Jonathan Payne, appear on behalf of the respondent, J.D. Wetherspoon PLC. Now, this appeal is a second appeal, although it's the first appeal by my client. It's an appeal against the decision of Mr. Justice Sweeting of the 21st of May of last year, in which he overturned the decision of the trial judge, Mr. Recorder Shepherd, on the 20th of September 2023, which had been in Mr. Berger's favour. It arises out of what was described by the recorder as a cowardly and appalling attack on my client as he was walking away from Wetherspoon's pub at Rodborough Buildings, Bridge Street in Guildford, by two security guards who were working on the door of the pub. The assault took place shortly before midnight on the 4th of August 2018, and it resulted in Mr. Berger suffering a dislocated and fractured hip, which required emergency surgery and several days in hospital. As you will note from the chronology, which is in the core bundle at page 56, after a period of pre-action correspondence, which started in 2018, the claim was issued on the 1st of April 2021. It was brought against two defendants, the general employer of the security guards, Risk Solutions BG Limited, and Wetherspoons, who owned and ran the pub in question, and where the security guards had worked for a number of years before the incident and continued to work there after it, with Mr. Hager, one of them, rising to the position of head doorman before both of them left to join the police. As against Risk Solutions, judgment in default of acknowledgement of service was entered on the 5th of August 2021. But Risk Solutions had already gone into voluntary liquidation in October of the previous year. And following the entry of judgment, the company was dissolved in October 2021. Risk Solutions didn't pay the claim, and based on the correspondence, which is referred to on page 56, with the Davies Group, with Risk Solutions insurer, in 2019, there was seemingly no insurance that responded to the claim. So the trial proceeded against Wetherspoons alone, who defended the claim on various bases, including that they were not vicariously liable for any tortious acts on the parts of the security guards. Now, this appeal concerns the first stage of the test for the imposition of vicarious liability, which is whether the relationship between the tortfeasors, that is the security guards, Mr. Hager and Mr. Talbot, and the defendant, that is Wetherspoons, was akin to employment, such that Wetherspoons was, or was also, in addition to their general employer Risk Solutions, vicariously liable for their acts. And the reason I have that qualification I'll come back to in relation to the issue of dual vicarious liability, which I say will be relevant when one is looking at the status of the contract. There is not on this appeal any issue about the second stage of the test for the imposition of vicarious liability, which is whether the conduct fell within the acts that the tortfeasors were authorised to do. It was an issue at the trial, and the recorder found that the second stage was satisfied. That was appealed by Wetherspoons unsuccessfully, and no cross-appeal has been brought. So the focus is just on stage one. Now, the recorder concluded after 3 days of trial in September 2023, and on the basis of the totality of the evidence before him, including the oral evidence, and focusing in particular on the actual position on the ground, the position in reality, that the first stage of the test was satisfied, and there was, on the facts of this case, an akin to employment, or we can call it quasi-employment, relationship between Wetherspoons and the security guards. On appeal by Wetherspoons, the judge overturned that decision and held that Wetherspoons was not vicariously liable for the security guards, and he did so giving primacy to the terms of the security services agreement between Wetherspoons and Risk Solutions in that regard. and I'll refer to that as the contract, and we'll come to that in due course. And we say the judge erred for two reasons. First, he applied the wrong legal test, that's our ground one. And second, that he went beyond the scope of what he was permitted to do by way of appellate review, and that's ground two. Our submissions will be structured in three parts. First, I'm going to address the applicable law on vicarious liability insofar as it's relevant to this appeal. And this will cover two things. Firstly, the correct approach in law to determining the first stage of the test for vicarious liability in a case such as this. And then secondly, and in relation to and in response to the points made by my learned friends in their skeleton, I'm going to look at the position of independent contractors in the law and the status of the contract, here the contract between Risk Solutions and Wetherspoons, in relation to the determination of the issue of vicarious liability. I'll also touch on the law relating to appellate review, but only in brief summaries. I know your lordships will be very familiar with that. Secondly, we will deal with the recorder's findings at trial, why he reached the conclusion he did, and whether he was correct in law to do so, and also what advantage he had as the trial judge in making the evaluative decision that he did. And Miss Moses will address you on that second issue. And thirdly, why on our case the judge on the appeal was wrong in his approach, and accordingly why we say you should allow the appeal. Now, the first section will take the most time, given the amount of law that has accumulated in relation to the issue of vicarious liability. The other two sections will be significantly shorter. So if I can turn now to the applicable law, but before I do, in order to provide the context for why I will be focusing on or highlighting certain passages or certain decisions, can I first take you to, if only by way of reminder, the judge's approach to the first stage of the vicarious liability test.
You mean the recorders, or?
No, I mean, I'm going to refer to Mr. Justice Sweeting as the judge, and I'm
yeah.
going to refer to Recorder Shepherd as the recorder, just to distinguish them.
Fine.
So if I can go to page 76 of the core bundle. And to paragraph 64. Now, this was the judge's summary here of the appellant's, Wetherspoon's argument. He stated there, the appellant's primary argument is that the recorder erred in imposing vicarious liability because Risk Solutions and its employees were in fact true independent contractors, providing specialist services pursuant to a contract. It's contended that the recorder failed to give adequate regard to the importance of this contractual relationship and the commercial reality of engaging an independent contractor. The appellant argues that BXB is not the leading authority on vicarious liability in this context and should be read in light of other relevant Supreme Court authority that defines the scope of vicarious responsibility and confirms the inability to apply it to true independent contractors, specifically citing Woodland, Barclays Bank and Cox. In the circumstances of this case, the recorder failed, it was argued, to accord the agreement the primacy it deserved in answering the threshold question as to whether Risk Solutions were independent contractors and placed too much weight on a series of factors which were only applicable in situations in which the true nature of the relationship was either uncommercial or opaque. So it was being argued by Wetherspoons that BXB was not the right authority to apply. It had to be read in light of previous authorities. That there was a threshold question of whether Risk Solutions were independent contractors, and that in deciding that threshold question, the contract was the most important thing for the court to consider. And it was being contended that the court should not look at the series of factors that we will see in BXB, the criteria, the principles that are used in order to determine whether a relationship between a tortfeasor and a defendant is akin to employment, unless the true nature of the relationship was uncommercial or unclear. Outside of those two contexts, it wasn't relevant. And the submission that was made to him, if we go to, if I can ask you to keep that open, but just have a look at the supplementary bundle. It's page 305. It's paragraph 29 on page 305. What was submitted was that this was a situation of a true independent contractor, and therefore there was no need to descend into consideration of either the principles in VXB or Catholic Child Welfare Society, which I'll refer to as the Christian Brothers case, because it was plain. As Baroness Hale made clear in Barclays Bank, and then there's an extract from paragraph 27 of Lady Hale's judgment, and I'll come back to this in due course. The key, as it was in Christian Brothers Cox and Arms, will usually lie in understanding the details of the relationship. Where it is clear that the tortfeasor is carrying on his own independent business, it's not necessary to consider the 5 incidents. So it was rooted in paragraph 27 of Barclays, and the statement that where it was clear the tortfeasor was carrying on his own independent business, you don't consider the 5 incidents. Now, those 5 incidents, as we will see, were actually policy factors. They weren't the criteria or details of the relationship that Lady Hale is referring to in the first sentence in that quote, which are used to decide whether the relationship is or is not akin to employment. The judge's own statement, if we go back to his judgment, it's page 81, of what he considered the law to be. It's at paragraphs 73 to 75. And he says at 73, I was going to take you to the top of page 81, to the 3rd line, was that while control remains a relevant factor in the modern stage 1 akin to employment test, the clarification in Barclays Bank requires a court first to determine whether the relationship is genuinely one with a true independent contractor carrying on their own business. If it is, vicarious liability does not arise, and the analysis of the factors for relationships akin to employment becomes unnecessary. And then at 74, he says, 3rd line, towards the right, the core question in the present case, informed by Barclays Bank and BXB, is whether the contractual and working reality of the relationship between Wetherspoons and the security staff engaged via contractors points to a relationship akin to employment or to that of a true independent contractor carrying on their own business. This involves considering the various features listed in VXB if the relationship is not clearly one or the other, rather than focusing predominantly on control, as was the emphasis in Hawley. And then at 75, I accept the appellant's submission that the recorder erred in his approach. The starting point must be the contractual relationship between Wetherspoons and Risk Solutions, which was for the provision of security services by an independent third party. The factors relied upon by the recorder, while indicative of some interaction and control between Wetherspoons and the door staff, are, in my judgment, entirely consistent with a business engaging a specialist independent contractor to perform services on its premises for pragmatic commercial reasons. So the judge accepted the submissions that had been put to him by Wetherspoons, and as he was invited to do, he approached, or appears to have approached, the issue of whether Risk Solutions were independent contractors as a threshold question, effectively asking if it was clear that it was an independent contractor relationship. He then took the contractual relationship between Risk Solutions and Wetherspoons as his starting point. We would say, in effect, he also took it as his finishing point, given his treatment of the oral evidence in relation to which he took his own view. And for reasons that Miss Moses will develop, we say wrongly, interpreted it as not inconsistent with the wording of the contract. And he then held it was clear...
Speaking for myself, it would be rather useful, before we go much further, to look at what the recorder said on this topic. You're saying that Mr. Yes. Justice Sweeting had no business to interfere, but yes. We don't know with what.
Yes. Well, I was going to come on to that, but let me just deal with It's page 131, which is the recorder's judgment. And he there says, I start with the law, and he says the leading authority on vicarious liability is now BXB.
Yes, you don't have to read out all that.
I'm not going to. He refers to paragraph 58. I'm going to take you to these authorities shortly.
Yes.
And then at 76, he was referred to other authorities, does not propose to quote, namely Barclays, Bank and Cox. And then refers to the decision of Hawley, which again I'm going to take you to. He said, I prefer to decide this case, as I intimated to the parties during the course of submissions, by applying the test in BXB to these specific facts and circumstances as they appear before me. But I do note the judgment in Hawley, which is incorrect spelling. I therefore turn to the present case. He says, as regards the first stage of the test, it's common ground Mr. Hager and Mr. Talbot were not employed by the second defendant. The question is, therefore, whether the relationship between the doorman and the second defendant was one akin to employment, applying the test as now set out by Lord Burrows in BXB. At 79, I need to remind myself, per Lord Burrows, in applying the akin to employment aspect of the test, I need to consider carefully the features of the relationship that are similar to or different from a contract of employment. Judgment continued before providing the list I've already cited. And then there was a submission by Wetherspoons at 80. Mr. Pink pointed out correctly, this is not a closed list. However, he then sought to argue that I was constrained to the terms of the contract, namely the contract between the second defendant and the first defendant for the provision of relevant security and door staff services, and that I could not consider the substance or nature of the relationship between the parties. I reject that submission. In my judgment, the focus here is on the nature of the relationship between the parties. The terms of the contract are, of course, an important feature of that landscape, but merely one of a number of features the court must consider and take into account. And then he turned to consider the factors set out by Lord Burrows in BXB, and Miss Moses is going to come back to that, so I won't deal with that now. It's worth looking at 100. He said, I well bear in mind what Lord Burrows said in BXB, that it's important to recognise that, as was made clear in Barclays Bank, that the akin to employment expansion does not undermine the traditional position that there is no vicarious liability where the tortfeasor is a true independent contractor in relation to the defendant. However, in my judgment, taking into account the totality of the evidence and weighing very carefully in the balance all of the factors identified by Lord Burrows and more, it is clear on the facts of this particular case that the first defendant was not carrying on its own true independent business in the sense set out by Lord Burrows in BXB.
Can I mention one thing I'd be grateful for submissions on at some stage, not now?
Yes.
There, the recorder is talking about the relationship with risk solutions.
Yes.
Back in paragraph 78, he's talking about the relationship between the doorman and Wetherspoons.
Yes.
They're not obviously the same thing.
They're not the same thing. And one of my submissions will be that stage one of the test, as we'll see, is concerned with the relationship between the tortfeasor and the defendant, not between the general employer of the tortfeasor and the defendant. The contract is clearly relevant because it may help to inform that relationship, but it's one part of the piece. But
and I follow the importance of that, and I see why you're putting it that way. Just pausing briefly on 100.
Yes.
Do you defend the last part of 100? Was Risk Solutions carrying on its own independent business?
What I say is that what his true focus, as one can see, was on the doorman and on the situation in this pub. And I would submit it was irrelevant whether Risk Solutions was carrying on an independent business. You focus on the tortfeasor. So we look at the security guards, and that may be informed, as I said, by the contract, but the contract isn't determinative of that relationship. The contract is much wider, and in a sense it's irrelevant whether Risk Solutions were carrying on a recognisably independent business, doing work for others, etc. What one is looking at is these doormen who were working at this pub for years, and how things operated in practice. What was the effective position on the ground? At 101, he said, I find no difficulty with that the first stage akin to employment aspect of the test is satisfied, considering all of the features of the relationship on the facts of this particular case. And then at 103, he refers to Mr. Payne, inviting him to stand back and ask if it's fair, just and reasonable to impose liability. Made the submission that if there's vicarious liability imposed, that has ramifications throughout the entire estate of Wetherspoons. I'll come back to that. And at 104, the reporter said that may well be so, but I've reached the decision that I do on the facts of this specific case. And then he found both stages of BXB were satisfied and that there was vicarious liability. So I hope that's helpful in identifying how the recorder approached it. So just going back to the judgment, as I said, the judge accepted the submissions and the approach that he was invited to take. And he then held, we see at 77, he refers to the contract. He held it was clearly an independent contractor relationship because the contract was a contract for services, not a contract of service at 77. And he held that the judge should not have viewed the factors that he did rely on as supporting a finding that the relationship was akin to employment in the context of a contract for specialist security services. We see that at 76, but also at 78, where he said that they were features of a standard commercial arrangement for the provision of specialist services by an independent contractor. So with that approach in mind, can I now take you to the authorities bundle? And I'm going to start at the end, as it were, with BXB, because that is the last decision of the Supreme Court on vicarious liability. And in it, yes, Lord Burroughs reviews the historic development of the law. We say it was, and it still is, the leading decision, and it took full account of the previous authorities, and it pulled them together into a set of principles applicable to vicarious liability in light of them, and specifically including Barclays Bank, on which Wetherspoons place heavy emphasis. And as you've seen, those are the principles which the recorder applied, and we say he didn't err in doing so. So I'm going to spend most of my time on BXB because it's a convenient and I think the most efficient way of actually encapsulating the relevant law from the previous cases. But I will then relatively briefly go back to some of the previous cases. They're all in the bundle, but I'll only do that insofar as it's necessary in light of Wetherspoon's arguments relating to those cases. In order to highlight relevant passages, in particular as to what was said about the position of independent contractors, because that's at the heart of Wetherspoon's argument as to why they say the judge was right in the approach he took to the first appeal. So I'm going to then, I should say, address separately some further authorities which consider the status of contracts in the determination of the issue of vicarious liability, as to whether a party is alleged to be an employer or akin to an employer versus an independent contractor, and the extent to which they do or do not preclude an analysis of the actual details of the relationship. So BXB, if I can go to that first, it's in the second authorities bundle, page 506. Now, in BXB, the claimant was a Jehovah's Witness who was raped by an elder, one of the spiritual leaders of the congregation. And she, along with her husband and children, had been close friends of the elder, his wife, and their children. The rape occurred at the home of the elder after they'd taken part together in door-to-door evangelizing. The elder was criminally convicted, and the claimant brought a claim for damages against the defendant, the trustees of the Jehovah's Witnesses congregation, and the worldwide organization that supported the activities of Jehovah's Witnesses, which then agreed to indemnify the trustees if they were held to be liable. The judge held that the trustees were vicariously liable. The Court of Appeal upheld that decision, and it was overturned by the Supreme Court. They found the first stage of the test was satisfied in that case, but the second stage was not, in that the wrongful conduct was not so closely connected with acts that the elder had been authorised to do that it could fairly and properly be regarded as having been done by him in the course of his quasi-employment by the organisation. Now, Lord Burrows, with whom the rest of the court agreed, started his exposition of the modern law on vicarious liability at paragraph 30 on page 518. And he noted there at 30 that it had effectively started in Lister, a decision of the House of Lords at 2002, one appeal cases 215, which concerned sexual abuse of boys at a school by the warden of the school. Now that was a case more about stage 2 of the vicarious liability inquiry, and it was the authority that recognised the close connection test. I simply want to note in passing, because it's a relevant theme, at paragraph 32, Lord Burrows picked up a warning by Lord Hobhouse in Lister at paragraph 60 of that case about not confusing policy reasons underlying vicarious liability and the rules defining the criteria for the application of the doctrine. You'll see the quote set out there, which I don't propose to read. As I said, that's a theme that I'll come back to, which is relevant to the appeal. At 35, Lord Burrows addresses the Christian Brothers case, which is in the bundle 1 at page 282. Just to briefly summarise the facts, and please do move me on if this is totally familiar to you, but the case concerned an institute which was a lay Roman Catholic order. Its mission was to provide Christian education to Christian education to children. Its members took vows of chastity, poverty, and obedience. They renounced any salaries payable to them for their teaching work that was paid over to the Institute, and in return the Institute met the Christian Brothers' material needs. In the 1990s, evidence emerged of a series of serious sexual and physical abuse of boys by teachers at a school known as St. William's, which had spanned more than 3 decades. And on a preliminary issue, the High Court determined that the defendants who had vicarious liability for any abuse which could be established were 2 diocesan bodies who had been responsible under statute for the management of the school and had employed the brother teachers. Now, the diocesan bodies were referred to as the Middlesbrough defendants, and the Court of Appeal upheld that decision. The Middlesbrough defendants appealed on the ground that the Institute, the Christian Brothers Institute, should share joint vicarious liability for the acts of its members. And the Supreme Court allowed that appeal and held that the Institute was also vicariously liable for the abuse. And if we look at paragraph 36, Lord Burrows identified that at stage 1, the Supreme Court, and it was Lord Phillips who gave the single judgment with which the justices all agreed in that case, laid down that the correct test was whether the relationship between the defendant and the tortfeasor was one that was akin to employment, and that in applying that test, especially at paragraphs 56 to 57 of Christian Brothers, that the relationship between a Christian brother and the Institute was akin to employment because it had all the essential elements of an employment relationship. That is, there was a hierarchical structure. The brothers were directed to undertake the teaching activity. They were doing so in furtherance of the objectives of the Institute, and they were required to conduct themselves as teachers within the rules of the Institute. It didn't matter that the brothers had not been paid as such, and that they were bound to the Institute by vows rather than contract. And at 38, Lord Burrows explained that Lord Phillips referred both to the criteria for satisfying vicarious liability and the policy reasons for the doctrine, and that at paragraph 34 he expressed the view it was important to consider both. At paragraph 35 in that case, he expressed the view, he identified 5 policy reasons, something he referred to as incidents, explaining the vicarious liability of employers being the deep pockets of the employer, that the activity is being undertaken on behalf of the employer, that the activity is part of the business of the employer, that the employer has created the risk of the tort, and the control of the employer over the employee. And he quotes paragraph 35, which he had just summarised. I invite you to just read the quote.
Yes.
And then he moves on to deal with Cox at 41, Cox and Ministry of Justice, which is in the bundle of 309 of bundle 2, where the stage 1 test was held to be satisfied, so that the Ministry of Justice, more specifically the prison service, was held to be vicariously liable for the tort of negligence committed by a prisoner carrying out work in a prison kitchen. Now, the claimant was a catering manager. They were moving supplies. She was moving supplies with the help of prisoners who were on prison service pay. A bag of rice was dropped. It spilt its contents. She instructed them to stop work until the rice was cleared, but one prisoner ignored that and attempted to push past her and dropped a heavy bag of rice on her back, injuring her. We see at 42, Lord Burrows identified that Lord Reid principally concentrated on the 5 policy reasons underpinning vicarious liability that had been articulated by Lord Phillips at paragraph 35 of Christian Brothers, and went on to make clear that the first and 5th of those policy factors, i.e. deep pockets and control, were of limited importance, and it was the other 3, tort committed while acting on behalf of the employer and as part of the employer's business, and that the employer had thereby created the risk of the tort, which were helpful in understanding the modern rationale for the doctrine. And then at 43, Lord Burrows identified the passage which addressed the criteria to be applied in determining whether the relevant relationship between a prisoner assigned work and the prison service was akin to employment. And he quotes from paragraph 34 from Cox. And again, I don't propose to read that out, I just invite you to consider that.
Yes.
And then at 44, Lord Burrows identified that Lord Reid had indicated there that sexual abuse cases were not a special category. The general approach to vicarious liability applied to such cases. Then at 46, he turned to the next Supreme Court authority on the subject, arms, against Nottinghamshire County Council, which is in the bundle at page 342. Now, this was a further judgment where a local authority was vicariously liable, held to be vicariously liable, but not liable for breach of a non-delegable duty of care for torts comprising sexual abuse committed by foster parents against a child in their care. And again, the leading judgment was given by Lord Reid, with whom the majority of the court agreed, Lord Hughes dissenting. The sole issue for vicarious liability was stage 1. And it was noted that the most important passage, just before the quote, you can see the most important passage was paragraph 60, where Lord Reid said the following. And again, rather than read it to you, I'd just be grateful if you would read the quote from that.
Yes.
Then at 47, Lord Burrows referred to Lord Reid, explaining the justification for vicarious liability being what's termed enterprise risk or enterprise liability. And then he turns at 48 to Berkeley's Bank. a Supreme Court decision in 2020, which was concerned with stage 1, in which Lady Hale gave the judgment. And he notes that one may detect behind that case and another decision handed down on the same day relating to stage 2, which was the Morrison Supermarkets case, an anxiety about the scope of vicarious liability being widened too far. And in both cases, the Supreme Court reversed the Court of Appeal and held that there was no vicarious liability. Now, at 49, he summarises the facts of Barclays. This was a case where the bank had arranged for pre-employment medical examinations to be carried out on job applicants, many of whom were teenagers applying for their first job. The bank arranged the appointments with a doctor, Dr. Gordon Bates, who they told the claimants when and where to go, and they provided the doctor with a pro forma to fill in. The bank didn't retain Dr. Bates or pay him a retainer, just a fee for each report, and the work he did was a minor part of his portfolio practice. The examinations and the assaults took place in a consulting room in the doctor's house, and the claimants alleged he had sexually assaulted them and sought damages from the bank on the grounds it was vicariously liable for the assaults. And at paragraph 50, Lord Burrows notes that Lady Hale made clear that the expansion of vicarious liability to include at the first stage whether the relationship was akin to employment didn't extend to rendering an employer vicariously liable for the torts of true independent contractors. And there's a reference to paragraph 29 of Barclays. The long-standing distinction drawn in the law of vicarious liability between employees and independent contractors remained of crucial importance. In that case, the doctor, in carrying out the medical examinations, was acting as an independent contractor and not as an employee of the bank. And then the quote from paragraph 24 of Barclays, Lady Hale said there was nothing in the trilogy of cases, that is Christian Brothers, Cox and Arms, to erode the distinction between employment relationships and relationships akin to or analogous to employment on the one hand, and the relationship with an independent contractor on the other. And then at 51, Lord Burrows noted that Lady Hale had also, at paragraph 16 of Barclays, identified that there had been a judicial, although there had been a judicial tendency to do so, one should seek to avoid conflating, eliding the criteria or principles that you apply in applying the stage 1 test with the policy reasons underlying vicarious liability as explored by Lord Phillips and Christian Brothers. And she pointed out the differentiation between the two in Lord Phillips' judgment. And then it was at paragraphs 56 to 57 of Christian Brothers that Lord Phillips had focused on the detailed features of the relationship and its closeness to employment, not on the 5 policy reasons which he'd set out at paragraph 35. Now at 52, Lord Burrows noted that Lady Hale concluded, and I would invite you again to read this quote, which is important in the present case.
Yes.
Some of that will be familiar because it was the subject of the submission I took you to on the first appeal. We say that in this passage, having identified the tendency to conflate the two, Lady Hale was distinguishing between the policy factors or incidents on the one hand and the details of the relationship or the criteria that you use, the test for stage 1 on the other. And she says that the question of whether the tortfeasor is carrying on business on his own account or whether he is in a relationship akin to employment with the defendant, and in doubtful cases where that distinction is not clear, the policy factors may be helpful in identifying is there a sufficient analogy to make it fair, just and reasonable to impose vicarious liability. And she gives a couple of examples. A technically self-employed person or an agency worker who are effectively part and parcel of the employer's business. But she says the key will usually lie in understanding the details of the relationship. So that means you apply the details of the relationship, the criteria, the principles to make that decision. But if having done that, it's clear that the tortfeasor is carrying on his own independent business, you don't need to consider the policy factors, the 5 policy factors or incidents. And note also the distinction between the technical position, one may be technically self-employed or an agency worker, and the effective position, where they are effectively part and parcel of the employer's business. So a distinction between the technical and the actual. If we go on to paragraph 58, we then come to Lord Burroughs pulling together the principles that can be derived from the previous authorities, in particular Barclays. And we see there that if we start at 58.1, stage 1 is concerned with the relationship between the defendant and the tortfeasor. So here, as we've already discussed, the focus is on the relationship between the tortfeasors, the security guards, and Wetherspoons, not Risk Solutions and Wetherspoons. And the latter's relationship will or may be relevant to the relationship between the security guards and Wetherspoons, because it's the reason, the impetus for that labour being provided to Wetherspoons, to work for Wetherspoons, work in connection with Wetherspoons. But that's not the focus. The focus is on the relationship between the tortfeasors and the defendant. And then at 2, the test at stage 1 is whether the relationship between the defendant and the tortfeasor was one of employment or akin to employment. And then he says in most cases that's not difficult because it's employer-employee. But in applying the akin to employment aspect of the test, a court needs to carefully consider features of the relationship that are similar to or different from a contract of employment, and then give some examples. Depending on the facts, relevant features to consider may include whether the work was being paid in money or kind, how integral to the organisation is the work carried out by the tortfeasor, the extent of the defendant's control over the tortfeasor in carrying out the work, whether the work is being carried out for the defendant's benefit or in furtherance of the aims of the organisation, what the situation is in relation to appointment and termination, and whether there is a hierarchy of seniority into which the relevant role fits. And then the emphasis is given again to, it's important to recognise, as was made clear in Barclays, that the akin to employment expansion does not undermine the traditional position that there is no vicarious liability where the tortfeasor is a true independent contractor in relation to the defendants. That was clearly reinforcing the distinction between the two categories, and that vicarious liability does not apply to a true independent contractor. Now, Lord Burroughs said that as was made clear, we go to 4, as was made clear in Barclays and Lister, the tests invoke legal principles that in the vast majority of cases can be applied without considering the policy justifications. The tests are a product of the policy, and in applying the test you don't need to continually turn back to look at the underlying policy. And he says that's not to deny that in difficult cases, and in line with what Lord Reid said in Cox, having applied the test to reach a provisional outcome on vicarious liability, it can be useful to check, to stand back and consider whether that outcome is consistent with the underlying policy. The core idea appears to be, he says towards the bottom below G, that the employer or quasi-employer who's taking the benefit of the activities carried on by a person integrated into its organisation should bear the cost, or one might say bear the risk, of the wrong committed by that person in the course of their activities. And then if we go forward to 65, in looking at the position in BXB, it was held that the lower courts had correctly held that the relationship between the elder and the Jehovah's Witness organisation was akin to employment. And at 66 and 67 over the page, he held the lack of payment wasn't decisive. The important features were that the elder was carrying out work on behalf of and as assigned to him by the Jehovah's Witness organisation, was performing duties that were in furtherance of and integral to the aims and objectives of that organisation. There was an appointments process for him to be made an elder, there was a removal process, and there was a hierarchical structure into which the role of an elder fitted. And a comparison was made with the features referred to by Lord Phillips in the Christian Brothers case at 67. That's going back to paragraphs 56 to 57 of Lord Phillips' judgment in that case. And then at 69, Lord Burroughs agreed with the judges below that save that he identified and considered it to have been a mistake to drift into talking about the risk of rape by the elder being assigned the activities he was given, because that was incorrectly to confuse the criteria for the stage 1 test with the underlying policy justification, and they should have considered just the criteria, not the policy factors. Now, what we draw from BXB as relevant to this appeal is that there is a recognised danger of conflating policy factors with the criteria for assessing whether a tortfeasor is in a relationship with the defendant akin to employment. The distinction between...
Sorry, just...
Sorry, I'm speaking too fast. So there's a recognised danger of conflating the policy factors
with the criteria.
With the criteria. The distinction between employment or akin to employment on the one hand and a true independent contractor on the other has been expressly confirmed. But if we go back to paragraph 52, which is quoting paragraph 27 of Lady Hale in Barclays, we say you do need to look at the details of the relationship, applying the criteria. If having done that, it's clear that the tortfeasor is an independent contractor, what Lord Burroughs refers to as a true independent contractor relationship, you don't need then to address the policy considerations. It's only if it's not clear and it's a doubtful case that you may then go to the policy factors to decide whether it's fair, just, and unreasonable to impose vicarious liability in that situation. But we say if you look at BXB, there's no threshold question where you simply ask, is it clear that there is an independent contractor relationship? Still less by reference to a contract between the organisation that employed the tortfeasor and the organisation to whom the tortfeasor was...
I'm not getting it down.
Again, I apologise, my lord.
No threshold question.
Tendency to speed up. So I'm saying, if you look at BSB, there's no threshold question. You don't simply ask, is it clear that this is an independent contractor relationship?
Yeah.
Still less do you do that by reference to a contract between the organisation that employed the tortfeasor, the general employer, and the organisation to whom the tortfeasor is supplied.
Does it matter that in law, in the present case, there's no legal relationship, no contract between the doorman and Wetherspoons at all?
No, there isn't. There is a contract of employment between the doorman and Risk Solutions, but not with Wetherspoons.
Yeah.
Yes.
In that respect, it's rather different from most of the Supreme Court cases.
Well, there was no contract in Cox between the prisoners, as it were, and the prison service for who were held to be vicariously liable. I'm going to come back specifically to the cases on where there isn't a contract, but there can be an imposition of vicarious liability where there is no contract between the tortfeasor and the employer. And we see that in the cases on dual vicarious liability in particular. So the employer may be held liable, or what they call the temporary deemed employer, the functional employer. There may be no contract of employment, but they can be held vicariously liable, or both can be held vicariously liable. But that's a specific situation where there will be a contract between the general employer and the temporary deemed employer, where the labour, the employee is supplied. And then the question is whether the relationship between the tortfeasor and the organisation to whom they're supplied is one that gives rise to vicarious liability. Is it akin to employment?
Can I just check an irrelevant detail?
Yeah.
There was obviously a contract between the doorman and Risk Solutions.
Yes.
You've referred to employment. Is it accepted that it was a contract of employment? I don't think it matters. But
Yes.
Yes.
Yes. I don't think we've ever seen it. Ms. Moses tells me, but that wasn't an issue.
No.
And obviously, because Risk Solutions didn't play any part in the trial, judgment having been obtained against them, one didn't end up, as one can in these cases, with a dispute between the general employer and the temporary deemed, quote, employer, unquote, as to who's responsible and whether there has been such a total transfer that, in fact, it's only the latter that's responsible. But I don't think that is an issue, my lord.
No.
So I was just to finish off on that, I was simply saying that the criteria are used by the court to make the determination as to which side of the line it falls on. And then if it's clear that it's on the wrong side of the line, it's an independent contractor, you don't go to the policy justifications. And I'll come back to the contract specifically and its status or weight. Now, I'm just going to briefly look at some of the prior authorities. And if we go to Barclays Bank at 378, in the same bundle. And I've already referred you to the relevant passages that were set out in BXB, you know, at 16, 18 and 27, so I'm not going to repeat those.
Yeah.
But can we first just look at what was being argued in Barclays? It's paragraph 8 on page 386. And what was being argued there was that the trilogy of cases, Christian Brothers, Cox and Arms of the Supreme Court, have replaced that proposition, the tribe proposition being set out at 7, that it's tribe law that the employer of an independent contractor is in general not liable for the negligence or other torts committed by the contractor in the course of the execution of the work. And it was being said that had been replaced with a more nuanced, multifactorial approach in which a range of incidents are considered in deciding whether it's fair, just and reasonable to impose vicarious liability upon this person for the torts of another person who is not his employee. So that was the argument that was being put there. And that was the approach that had been adopted in that case by the trial judge and by the Court of Appeal. And the Supreme Court said that was wrong, and it perhaps explains why it was so keen, the Supreme Court was so keen to emphasise, as it did repeatedly, that no doubt had been cast by those earlier decisions on that conventional trite distinction between employees and those analogous to employees and independent contractors. And we see that emphasis. We've picked up one of these already, but at paragraph 19 on page 390, you see that emphasised, and at paragraph 22, towards the bottom, C, and again at 24. I'd just ask you at the moment, and purely at this stage, just in passing, I'm going to come back to it shortly, but if we go back to paragraph 12 on page 387, Lady Hale identified that the first English case to consider directly whether the inquiry at stage 1 might expand beyond the relationship of employee and employer was E's case in 2013 QB 722, and E's case is referred to at paragraph 9. It was E against English Province of Our Lady of Charity, a Court of Appeal decision, and she said that this built upon the earlier decision of Via Systems against Thermal Transfer Northern Limited, 2006 QB 510. And I'm going to come to this, so I'll deal with it then, but you'll note at the end of paragraph 12, thus was vicarious liability extended to a person who was not in law the employer of the tortfeasor. As I said, I'll come back to that very shortly. What I want to do in this case at the moment is just to focus on what assistance there is as to the distinction between employees and quasi-employees on the one hand and independent contractors on the other. And if we go to paragraph 19, we see there that there is a quote from Lord Sumption in Woodland against Swimming Teachers Association, as to and you'll see the end of that quote just below between B and C, as to the vicarious liability has never been extended to the negligence of those who are truly independent contractors, such as Mrs. Stopford appears to have been in the Woodland case. Mrs. Stopford was somebody to whom the performance of compulsory swimming lessons had been delegated. My learned friends rely on the observation that it was sufficient to simply to refer to the appearance of independent contractorship without examining the features of the relationship. I just pause to note that there couldn't have been any such examination because the facts in that case were never found. The wrong cases in the authorities bundle, but in the correct decision, which we can provide to you if you'd like to see it. It was observed at paragraph 2 by Lord Sumption that the case had been struck out by the judge on the basis of pleadings and assumed facts, and regardless of the outcome of the appeal, which only related to negligence and a non-delegable duty of care, it would need to be remitted to the High Court for fact-finding. So what the statement of Lord Sumption, we would say, was seeking to do, which is quoted here at paragraph 3, was to confirm that the doctrine of vicarious liability had never been extended to independent contractors. And his comment in relation to Mrs. Stopford was as far as he would have been able to go without any facts having been found. Indeed, it may well have been the subject of a concession in that case because the preliminary issue was proceeding solely on the basis of whether there was a non-delegable duty of care, not vicarious liability at all. So if I go now to paragraph 21 of Barclays, there's reference there to Cox. And to Lord Reed, repeating, if you see at the bottom of page 319 to the top of the page, repeating the distinction between integrated activities and activities entirely attributable to the conduct of a recognizably independent business of the tortfeasor or some other person. But the reference to business and enterprise didn't mean that the employers, that is the defendants' activities, had to be commercial in nature.
What about the reference there to an independent business of the tortfeasor or some other person?
Yeah. That would appear to be extending it slightly further, but in my submission, the stage 1 test is conferred, is focused on the tortfeasor.
So can one attribute any meaning to the reference to or some other person?
Well, I mean, that will be a matter for the court to consider in light of the submissions by each side, but we would say, and we're not suggesting that the position of Risk Solutions is irrelevant, as I've said, or that the contract is irrelevant. Indeed, the judge regarded it as an important feature when considering the relationship between the tortfeasor and Wetherspoons. But it was part of the landscape. It wasn't the whole of the landscape, whereas Mr. Justice Sweeting appears to have treated it as determinative. And we would say that when one is looking at whether there's a recognisably independent business, you're really looking at the tortfeasor, and you're not looking at his general employer, who may well have a recognisably independent business, but we would say that's irrelevant.
Can I just think around that for a moment? I mean, an employee is never going to have an independent business of his own.
Sorry,
So suppose you have an independent contractor who employs someone, and the someone does something wrong. someone is never going to have an independent business of his own, is he? He works for the employer.
No, he does. You might have somebody who is, turning up to do some work at one's house, they're a sole trader, they have their own business. So that could be, the sort of technically self-employed person. But you're right, in the dual vicarious liability case law, and I'd like to come on to that,
Yes.
you will see that they're not going to have a recognisably independent business. And yet, if that person who has been supplied becomes so embedded in the organisation of the entity to whom they've been supplied, that can give rise to an akin to relationship vicarious liability scenario. So I'm conscious of the time. May I just briefly refer to Kafagi, which Mullin and friends rely on. It's dealt with at paragraph 25. And that was a situation where the defending company, JBW, had a contract with a local authority to collect their council tax debts. It subcontracted the work to a registered bailiff, the alleged tortfeasor, Mr. Boylan, who ran his own business, and he could pick and choose what work to do. He had his own insurance, he could work for other clients. And the relationship between JBW Group and Mr. Boylan was held not to be akin to employment. The alleged torts were assault, battery, and executing an unlawful levy. And there was another bailiff that Mr. Fennick, who Mr. Boylan had taken along with him. And I won't go to it now, but the Kafagi case is in the bundle. It's same authorities bundle 2 at page 339. And I would just ask you to make a note. It's paragraphs 50 to 54. Which explains that he ran his own business. He could turn down work from JBW. He could conduct collection of debt in whatever legal manner he saw fit, without any control from JBW. He could decide not to collect the debts. He could share that work with somebody else, as he did in bringing along Mr. Fennick. He provided a personal bond as a regulatory matter that was nothing to do with JBW. He was more of a potential competitor then integrated into the JBW business, and there wasn't even the vestigial degree of control to which Lord Reid had made reference in Cox. So the factors in that case, that bailiff relationship with the company who gave him work, was held to be an independent contractor situation. And then at 26, we have Lady Hale referring to the case of Ing Wat Sung and Madmi, a Singaporean decision of the Court of Appeal in 2017, where a similar argument to that was being run in Barclays was presented by the appellants in that case. And it was being argued recent decisions had undermined the distinction between employees and independent contractors, and that argument was firmly rejected by the Singaporean courts, including the Court of Appeal there. Now that was a case which related to a demolition contractor who'd been engaged by the respondents to carry out demolition works on their property. And as a result of debris falling onto the neighbouring property, there was damage to the neighbouring property and to the boundary wall. And it wasn't disputed that the demolition contractor was negligent. The question was whether the respondents who'd engaged the demolition contractor were also liable, including on the basis of vicarious liability for the negligence of the contractor. And the court said no. And you can see the reasoning for that set out at paragraphs 26 and 27 of Barclays. And again, I just ask you to briefly have a look at that. Now, that was not a situation where an employee was hired out as I said, I'm subject to one further authority. I'm going to come to that. Just finally, on the subject of what is an independent contractor, could I go for completeness to the case of Hughes and Ratton in 2022, 469, decision of the Court of Appeal, which post-dated Barclays and predated BXB, but isn't referred to in BXB. My Lord Justice Bean gave the judgment in that case, so I propose to take it quickly. Claimant was a dental patient at a practice owned by the defendant, which provided NHS dental care. She brought a professional negligence claim against the defendant in relation to care provided by 3 self-employed associate dentists who'd signed associate agreements, as well as an employed assistant dentist. A preliminary issue was ordered on whether the defendant was liable for the acts or omissions of the treating dentists, either by virtue of a non-delegable duty of care or by virtue of vicarious liability. The judge found the defendant liable on both bases of liability. The defendant appealed. The Court of Appeal dismissed the appeal, upholding the finding of non-delegable duty of care. And if we look at the per curiam at the bottom of page 469, we see what was held in relation to vicarious liability. Again, can I just ask you to read that?
Yes.
And if I go forward to paragraph 84, the discussion of vicarious liability.
It's all overture in a sense, because we had already found for the claimant on non-delegable duty, but we were asked to deal with vicarious as well.
Yes, ultimately the appeal was dismissed, but just to look at what was said. And as an example of where it has been held that there is no vicarious liability because of an independent contractor relationship. At paragraph 84, and this was something that the judge relied on, my lord said that the defendant's case on vicarious liability in a nutshell is that the judge attached too much weight to factors pointing towards his relationship with the associate dentist being akin to employment, too little weight to the factors pointing the other way. And you said, I appreciate that a multifactorial evaluation by a trial judge is one with which this court should be slow to interfere, but where the primary facts are very largely undisputed and the preliminary issue is one of law, the deference to be accorded to the trial judge's evaluation is reduced. I'll come back to that when I address the law applicable to ground 2, but just to note it for the moment while we're here. And then at 88, it was held that the relationship was closer than that the critical question now appears to have reverted to being whether the alleged tortfeasor's relationship with the defendant can properly be described as being akin or analogous to employment, with the focus being on the contractual arrangements between the tortfeasor and the defendant. My learned friends rely heavily on your lordship's statement that the focus must be on the contractual arrangements between the tortfeasor and the defendant. However, as we understand the statement, especially given that there's no principle stemming from Lady Hale's judgment in Barclays that the contractual documentation is to be given a primary or still less decisive weight, as my learned friends contended. As we understand it, it's rooted in the fact that the contractual documentation in that case, in Hughes and Ratton, mirrored the position on the ground. And what we understand, my lord, and you will obviously understand it better, to be saying was that the focus must be on the details of the relationship, as Lady Hale said in Barclays. Of course, in the instant case, as Ms. Moses will go on to develop shortly, there's a divergence between the contractual documentation and the position on the ground as revealed by the other evidence. we submit respectfully that my Lord's statement, simply taken and applied in the present context, is liable to be misconstrued. And then at paragraph 89, just to note the points that led my Lord to conclude that this was not an akin to employment relationship. And you said at 90 there were 2 points going the other way, but at 91, albeit with some hesitation, you differed from the judge on the issue of vicarious liability. So it's just to draw attention to the factors you looked at and considered to be relevant. But you did the analysis. Was it akin to employment, or was it an independent contractor relationship? You looked at the details of the relationship, which is the point we make. You're entitled to do that. I want to just briefly go to the respondent's case on the contract, so that, again, you have the context for me taking you to some cases on it. If we go back to the core bundle at paragraph 48 and look at the respondent's skeleton on this appeal, I'd be grateful if you could keep the authorities bundle available, because I'll be back to it very shortly. You see at paragraph 19, it said, in none of the akin to employment cases has there been a contract for services between the parties. And then at 20, in none of the trilogy of cases was the court required directly to address the question whether the relationship between an employer and an independent contractor might also be regarded as analogous to employment. The reason for that gap is obvious. The contract for services itself precludes such considerations. And then if we go forward to 29, it said, this case is simple. Risk Solutions is an independent business, just as Boylan was in Calgary, Dr. Bates was in Barclays Bank. And then there's a quote from Charlesworth on negligence, referring to the proper sphere of application of the vicarious liability test is to non-contractual relationships, which is stressed, and to atypical working relationships involving persons who are neither employees nor independent contractors. And then at 40, it said there doesn't need to be consideration of the relationship between Wetherspoons and Risk Solutions over the recognition that there is a contract for services, and this is not a sham. And this contract sets out the fact of being an independent contractor. Now, Ms. Moses is going to deal with the contract and what it in fact says, but I want to go to just some authorities that are relevant, as I said, to those points of law advanced as propositions of law by Wetherspoons. And I would just draw attention to the fact that this case was originally pleaded as a dual vicarious liability case. If you look at page 151 of the core bundle, you'll see from the particulars of claim, because it was against both defendants, paragraphs 13 and 14.
Sorry, which page?
151 of the core bundle. Again, I just invite you to have a look at that, particularly paragraph 14.
Yes.
If we look at the supplementary bundle at 317, on the first appeal, a respondent's notice was served by Mr. Berger, inviting the appeal court to uphold the decision of the learned judge for the additional reason that the appellant was the temporary deemed employer of the door staff. They were jointly liable, jointly vicariously liable. Now that didn't arise. It didn't arise before the recorder in the end, because he found Wetherspoons were vicariously liable. He didn't need to consider whether Risk Solutions were also liable. They played no part in the trial. And then the judge, as we'll see, it's paragraph 69 of his judgment, page 82 of the core bundle. He said his conclusions that Wetherspoons were not vicariously liable were also fatal to any attempt to analyse the relationship as giving rise to dual vicarious liability, or temporary deemed or transferred employment. So it was an issue. It wasn't necessary to decide it, but the cases relating to it are relevant to this issue of the status of the contract in relation to that decision. Because where dual vicarious liability is being considered, there will be a contract in relation to the transfer of employment or transfer of the employee. So if we start with Via Systems, it's in Bundle 1 at page 208. I mentioned it already, and it was explained that had been built on to the starting point for the akin to contract line authority, which extended vicarious liability beyond employees. Via Systems was a case where the claimant had engaged the first defendant to install air conditioning in their factory. The first defendant had subcontracted that to the second defendant in terms of the ducting work. The ducting work was carried out by a fitter and his mate, who was supplied to the second defendant by the third defendant on a labour-only basis, but under the supervision of the fitter acting or working for the second defendant. The fitter's mate, Darren Strang, was sent to get some fittings, and then instead of coming back by some sensible route, inexplicably crawled along some sections of the ducting and then fractured the fire protection sprinkler system, resulting in severe flood damage. And the judge had held that only the third defendant was vicariously liable for Mr. Strang's negligence. The Court of Appeal overturned that and held that both the second and third defendants were vicariously liable. And Lord Justice May and Lord Justice Ricks each gave their own judgments. They agreed on the result, but their reasoning differed. And in the interest of time, I'm not going to spend much time. I'm just going to draw your attention to the passages on Lord Justice May, because the Supreme Court has approved the Ricks, Lord Justice Ricks' approach as the preferred approach. But at 16...
Sorry, I may have missed this. The answer to this obvious question: who employed the fitter's mate?
I think that was the third defendant.
Yeah, on a labour-only basis.
On a labour-only basis, yeah. Was supplied on a labour-only basis to the second defendant, and the question was whether the second defendant was vicariously liable.
Yes, I understand that.
The employment was with the third defendant. So Lord Justice May, paragraph 16, the inquiry, this is 5-6 lines down, the inquiry should concentrate on the relevant negligent act and then ask whose responsibility it was to prevent it, who was entitled and perhaps theoretically obliged to give orders as to how the work should or should not be done. In my view, entire and absolute control is not, at least since the Mersey Docks case, a necessary precondition. I should have said that Via Systems overturned what had been understood to be a position of you couldn't have dual vicarious liability created. It said it was possible, notwithstanding it hadn't been done. There was nothing precluding it, and so the court was looking for the first time at the law on this. So he focused on the negligent act, whose responsibility was it to prevent it, and then at 18, he said at the top of page 217, the core question is who was entitled and, in theory, if they had the opportunity, obliged so to control Darren to stop him crawling through the duct. In my judgment, the only sensible answer to that in this case is that both Mr. Megson and Mr. Horsley, so the D2 fitter and the D3 fitter, were entitled and, in theory, obliged to stop Darren's foolishness. Mr. Megson was the fitter in charge of Darren. Mr. Horsley was the foreman on the spot. And they were both entitled and obliged to control Darren's work, including the act which was his negligence. The second defendants, through Mr. Horsley, would, I think, have qualified for vicarious liability if it had been Mr. Megson who foolishly crawled through the duct. And then at 49, we have, if on the facts of a particular case the core question is who is entitled and in theory obliged to control the employee's relevant negligent act so as to prevent it, there will be some cases in which the sensible answer would be each of the two employers. The present is such a case. And then if we go forward to page 234, Lord Justice Ricks agreed with the possibility of dual responsibility at 77. And at 78 agreed with Lord Justice May's analysis of the facts as demonstrating a situation of shared control, but at 79 suggested a broader test. We see that at three lines down on page 235, he suggested liability should arise when the individual is so much a part of the work, business or organisation of both employers that it is just to make both employers answer for his negligence, and that vicarious liability was imposed because the functional employer was treated as picking up the burden of an organisational or business relationship undertaken for his own benefit. The focus, as we see, is on the employee in question, vis-a-vis each of the defendants who is argued to be vicariously liable, the general employer and the temporary employer. And at 80, one is therefore looking for practical and structural considerations. And then he gives effectively three categories. He says, is the employee in context still recognisable as the employee of the general employer, and in addition to be treated as if he was the employee of the temporary employer as well? In the Mersey dock situation, it's tempting to think liability will not be shared. So that's an example where vicarious liability stays solely with the general employer. And then at just below D, one could contrast the situation where the employee is contracted out labour, he's selected and possibly trained by his general employer, hired out by that employer as an integral part of his business, but employed at the temporary employer's site or his customer's site using the temporary employer's equipment and subject to the temporary employer's directions. In such a situation, responsibility is likely to be shared. So there you get dual vicarious liability. And then a third situation where an employee is seconded for a substantial period of time to the temporary employer to perform a role embedded in that employer's organisation is likely to result in the sole responsibility of that employer. And then 81 is also relevant to the contract issue. There's the question of contribution between two employers who are both vicariously but only vicariously liable. In principle, they will generally be able to contract between themselves as to the basis of contribution. In practice, any such contract is likely to place responsibility entirely on one side or the other, often accompanied by further provisions regarding insurance. In such cases, while both employers will each be fully liable to the claimant, only one will be liable inter se, for the effect of their contract will be recognised within contribution proceedings. Since the doctrine of vicarious liability is for the benefit of the claimant, and since the employers are able to contract as to their liability inter se, it seems to me unnecessarily restrictive to insist on the impossibility of a dual vicarious liability. And as I've said, it was in the Christian Brothers case. I'll just give you the reference to it. It's paragraph 46 of that case where the approach of Lord Justice Ricks was preferred. To take you to Hawley and...
Sorry, can I just...
I'm so sorry.
Get, can I just see where that does happen so I understand it? I don't think it's paragraph 46 of Christian Brothers.
Oh, no, you're right. It's
mentioned at 39.
It's 45 at the last line. In
I see.
considering the question in relation to each defendant, the approach of Rick's LJ is to be preferred to that of Lord Justice May. If I can go to Hawley, Luminar Leisure, at 237. This was an analogous case to the present one on the facts, because the first defendant, Luminar, a company that operated nightclubs, engaged a security contracting company, ASE, to provide doormen, including at Luminar's club in Southend. The doorman in question, a Mr. Warren, had worked at the club, Luminar's club, for over 2 years prior to the incident where, in the course of his work as a doorman, he punched the claimant, causing him to fall, fracture his skull, and suffer permanent brain damage. He was convicted of causing GBH to Mr. Hawley. ASE went into liquidation. Default judgment was obtained against ASE. It took no part in the trial, but its public liability underwriter did participate. And the relevant issue at the trial was whether the doorman in question had been a temporary deemed employee of Luminar, so as to fix Luminar with vicarious liability for his tortious act. And the judge held Luminar was vicariously liable for the doorman's acts. All of the parties at that point were proceeding on the basis that only one of the defendants could be vicariously liable for the doorman's acts. Luminar then appealed, contending it wasn't vicariously liable, but if it was, following bias systems, it was a dual vicarious liability situation. And the Court of Appeal upheld the judge's decision that Luminar was vicariously liable and considered that only Luminar was vicariously liable on the facts of that case. It was actually said in Christian Brothers, in the wrong reference I gave you was I think it was to 46, that it was arguably a case of dual vicarious liability, but that wasn't how it was decided. The judge in this case, who was then Mr. Sweeting, QC, acted as counsel for Luminar. His arguments were unsuccessful in that case, but they bear some parallels to his approach in his judgment here. And they're set out at paragraphs 13 to 14. There was a contract between Luminar and ASE, the terms of which again has parallels with the present case. I'm not given time going to go through it, but can I invite you to look subsequently at paragraph 40 onwards. It was for the supply of security services. There was standards of service in Schedule 2, as Ms. Moses will show you, similar to our contract. There were warranties of suitability and training given by ASE. 43 is a reference to uniforms, in that case those specified by Luminar. There was at 44 an indemnity by ASE to Luminar against all liabilities arising from or connected with the provision of the services of the acts and emissions of the stewards. And Luminar required ASE to take out proper insurance cover. And at 45, it was agreed that nothing in the agreement would render, ASE agreed, nothing would render their employees employees of Luminar. ASE would have discretion as to which stewards were provided, but if Luminar didn't approve, they would not be provided. And at 57, the judge also had witness statements and heard oral evidence from several people. At 60, the effect of that evidence was that when she said jump, the doorman would jump. This was Mrs. O'Brien, the manager of the club. And at 62 and 63, there was a contrast drawn between the witness statement and the oral evidence of the head doorman, Mr. Pullman. 67 is important. and this was what the judge had found on the basis of the evidence. And can I ask you to look at that, but particularly to look at the passage at the bottom, which relates to the arrangements between Luminar and ASE concerning who was to be the employer of stewards and who should bear and insure against the risk of liability to third parties by reason of the conduct of the door stewards cannot override the clear factual position which vested control over how the door stewards did their job in Luminar Club management. And this was cited without disapproval by the Court of Appeal. So the contract did not override the factual position on the ground. And then, so to just draw your attention to it, at 68, the arguments of Mr. Sweeting were set out on why, on behalf of Luminar, they should not be found vicariously liable. And those were rejected, and it is worth looking in more detail later at the reasoning that was adopted in that case from 70 onwards, that it was a contract for the provision of labour only. No complicated machinery was involved, no particularly specialised skills were involved. Whatever one calls them and whatever their additional duties, the job of a doorman is in essence a fairly basic one, namely keeping the peace. Talked at 72, restraint, not a particularly specialised skill. 73, security was at the heart of Luminar's operation, no licence meant no business. 74, Luminar could have employed and trained their own door staff. 76, the Luminar manager was an overall charge of security. 77, Luminar decided who to exclude, admit, reject, etc. And 78 to 79, detailed control exercise, not only over what the door stewards did, but how they were to do it. At 81, it was open to the judge to make the finding that Luminar had become Mr. Warren's deemed employer, and responsibility for Mr. Warren's acts lay with Luminar. So I caveat my reliance on Hawley because it predated Barclays, which reinforced the distinction between employment and vicarious liability relationships. And it was a decision heavily based on the extent of control, which in Cox, Lord Reid made clear signalled there had been a shift away from. It's not irrelevant, but not as important as it was. So those developments have to be borne in mind. But it's still clear that the contract between the security company ASE and the club Luminar was not determinative of the issue of vicarious liability. And it didn't preclude an analysis of the actual relationship between Mr. Warren, the tortfeasor, and Luminar, the club. What the court was doing, and we see this at 79, was looking at the reality of the situation. And it was held that he was entitled to do that. The final case I'm going to go to is NatWest and Bilter. It's page 420 in bundle 2. This is again relevant to the contract. This postdated Cox and Barclays. Just by way of summary, it was an investment bank, RBS as it was, and its indirect subsidiary RBS Seal, S-E-E-L. Both of them appealed against a decision that they were liable for dishonest assistance in respect of a missing trader fraud in carbon emissions trading in 2009. The respondents were companies that had become insolvent after being used as vehicles for the fraud. RBS Seal traded carbon credits on the bank's behalf. Its trading desk was manned by 2 traders who were employed by RBS Seal, but they were seconded to the bank under the terms of an agreement. And the judge found that the traders had dishonestly assisted in the fraud. RBS Seal argued that the judge, Mr. Justice Snowden as he then was, had erred in finding it to be vicariously liable for the acts of a dishonest assistance by the traders. And the contractual relationship in that case between RBS Seal and the traders was governed by a Commodities Trading Activities Master Agreement, the CTAMA. And it was said the judge had misconstrued that agreement in finding vicarious liability. The Court of Appeal upheld the finding of vicarious liability by both RBS and RBS Seal. It was held the judge had made an error in construing the contract, but that wasn't fatal to his conclusion that RBS Seal was vicariously liable for the traders, because he had been right to hold that they had authority to perform their trading activities as agents for the bank, binding the bank to trades and so on, but subject to Seal's supervision and control over the traders. And it was via a different provision of the contract that the finding had been correct. And the judge had been entitled to decide that the traders were so much a part of the business of both the bank and Seal that both were vicariously liable for them. Now, just to give you the references to that, it's paragraphs 171 to 175 and 185. But the thing I want to pick up in this contract, in this decision, is the relevance of the contract. If we go to 160, just note in passing at 156 that the Court of Appeal pointed out that the imposition of vicarious liability is a highly fact-sensitive exercise, all the more so in circumstances in which an employee has been loaned or hired out or seconded to another organisation. But at 160, and we say this is important, we acknowledge that the terms of an agreement between the employer of the wrongdoer and the party to which he has been loaned, hired or seconded cannot be determinative of the issues which are relevant to the imposition of vicarious liability. The imposition of liability is based on the principles to which we have referred and which have been developed and approved by the Supreme Court. It's not possible, for example, to avoid the imposition of vicarious liability purely as a result of having reached a contractual arrangement with the body to which an employee is loaned, that it will bear all loss in relation to his or her conduct, or that the employee should be treated solely as the employee of that organisation at a particular time. One cannot contractually opt out. Vicarious liability is imposed as a matter of policy, not concerned with fault or with contractual liability. And at 161, it was upheld. It was said in that case the contract, because it was criticised that the judge had dealt with all of this through the medium of the contract, but it said it was common ground that it reflected the realities of the arrangement. Same points are made at 181. Now that's in contrast to the position here. Just going back to what the respondents have said, they said in none of the akin to employment cases has there been a contract for services between the parties. It's unclear who they mean by the parties, but it's certainly the case that where you have a loaning out, a hiring out, a seconding of an employee pursuant to a contract for services between the general employer and the temporary employer, which involves the supply of labour, you can have vicarious liability. And these three cases, via Systems, Hawley and NatWest, all involve that contract, but they don't preclude an analysis of the details of the relationship. And it doesn't preclude a finding of vicarious liability if the reality is such that it is akin to employment. And there is nothing in the authority suggesting that that contract precludes consideration. As I've said, my submission is that's an erroneous misinterpretation of what Lady Hale said in Barclays at paragraph 27. She said, if it's clear, having considered the details of the relationship, then you don't look at the policy factors. It's not that you don't look at the criteria, at the details of the relationship to make that decision. And the real relevance of the contract in my submission, as per via Systems paragraph 81, is in relation to any subsequent and separate redistribution of the liability as between the defendants. And that's where it matters, but as a matter of public policy, you look at vicarious liability vis-a-vis the claimant without consideration of the contractual liability of the contractual relationship, save insofar as it's relevant to applying the test, applying the principles. My Lords, I'm not going to deal with scope of appellate review just because of time. I'm going to hand over to Ms Moses now to deal with what the recorder held, and then I'm going to deal briefly with why we say the judge got it wrong, and that's really just to pull everything together.
Right. Yes, Ms Moses.
My Lords, I'm going to address you now on the evidence at trial. We've made submissions in writing about these matters, and I'll just give you the relevant paragraphs of our skeleton in your notes so that you know what it is I'm amplifying when I'm addressing you. It's really at paragraphs 41 and 42 of our skeleton, which appears in the core bundle at page 39. And I'm mindful that as I prepare to address the court on points of evidence at first instance in this, which is a second appeal on points of law, the court's immediate concern is, of course, the judge's application of the law. But of course, if the judge's order is overturned as we seek, then the recorder's order is reinstated. And I wish to draw out three short but important aspects of the way that the evidence unfolded at trial, because we say that these 3 points help to explain why the judge, the recorder, reached the decision that he did, why he was right to do so, and why the judge was wrong to interfere with that decision. Those 3 points in outline are, first, the contract. So this appeal is at its heart about the weight that should be given to that contract, and it's important in my submission that the court understands what it actually says. And so I propose to take the court to it.
Yes.
Second, what was the other evidence? This came from Wetherspoon's disclosure and from witnesses. Wetherspoon's position in this appeal is that it should be ignored. And if that's to be done, then in my submission, again, it's important that the court understands what it is that it's being asked to ignore. Those first 2 points in my first 2 headline submissions relate to ground 1, and my third point relates to ground 2, and that is, to what extent did the recorder have an advantage in this case over both the judge and this court in assessing the evidence, in making the evaluative decision that he did. In a normal case, this wouldn't properly be in dispute, but because of the judge's findings, it appears to be. In taking the court through these 3 points, I hope, or endeavour to show, first, that the contract does not clearly show that the relationship between the tortfeasors in this case and Wetherspoon's was one of an independent contractor. The contract doesn't paint a complete picture of that relationship, the relevant relationship. But if anything, the picture that it does paint is one of a contract of service and the supply of labour. Second, my second overarching submission in relation to the other evidence is that does paint a clear picture. It paints a picture of a relationship that is akin to employment, and one that amply meets the test at paragraph 58 of BXB.
Sorry, the relationship between whom and between Wetherspoons
And the tortfeasors, always. I won't.
And the individual.
In the individuals. I won't, my lord, be addressing you at any stage on the relationship between Wetherspoons and Risk Solutions. First, because there was no evidence of that, apart from the contract itself, and nothing else to explain it. And second, because as Ms Mulcahy explained, our position is that that is not the relevant relationship for the purposes of the issues that the court has to determine. So if ever I'm not clear, unless I say otherwise, I'm referring to that relationship, the relevant one, between Mr Hager and Mr Talbot, who attacked our client and caused him very serious injuries, and Wetherspoons. So to pick up, it's the second point is that the other evidence paints a clear picture and it amply meets the test at 50A to 50B. And third, that this was a trial in which there was a lot in dispute, so not like my Lord Lord Justice Bean's experience of the facts in Hughes and Rattan, as my learned friend Miss Mulcahy explained, and where a lot turned on the oral evidence, the evidence given during cross-examination. And this put the recorder in a unique position, as I say, to assess the evidence and to evaluate it and reach the finding that is ultimately unchallenged in this appeal. Turning to my first point, this is the contract.
Yeah.
It can be found in the supplemental bundle at page 7. It's 22 pages. While my lords look for it, just some facts about it. It's 22 clauses as well, and it has 4 schedules.
Yes.
I propose, if we can keep that document open, but what I propose to do as well is to take you to what Wetherspoons say about this contract, which do they say are the relevant clauses, and to look at the two together. That's in the core bundle at paragraph, at page 25.
Sorry, which page?
25.
25. Sorry, that's in the skeleton, is it?
That's their skeleton. It's paragraph 25 of their skeleton, and it's also page 25 in the core bundle. Conveniently, they're in separate bundles, so I hope that I can make submissions on both documents without causing too much irritation. They make 3 reference, I say, to 3 clauses of this contract at paragraph 25. That's where they set out their stall and they say, these are the provisions of this agreement that render this case a clear case of an independent contractor. First, they refer to the fact that Risk Solutions, that's not tortfeasors, Risk Solutions has a separate company number. And we can see that, and it's not in dispute, in the contract on page 2, so that's supplemental bundle, page 7. Second, they rely on clauses 3.7 and 3.8. This is where some statements are made between Risk and Wetherspoons about who has control. And we can see those in the supplemental bundle at page 10. And what those clauses say is that Wetherspoons shall under no circumstances have control and Risk Solutions shall retain it. And third, they rely on clause 6, which is in the supplemental bundle at page 12, if my lords want to look at it, under which Risk Solutions was obliged to ensure the activities of the security staff, the tortfeasors. And 2 points arise in our submission from Wetherspoon's reliance on these clauses, as this is the high point of their case on this contract, as to why this document paints a clear picture of the relevant relationship being an independent contractor. The first point that arises, and I've already alluded to it, is that as Miss Mulcahy explains in response to my Lord Justice Newey's intervention, that the relevant relationship is the one between the tortfeasors, that's Mr. Hager and Mr. Talbot, and not between Wetherspoons and their employer. And the contract tells us very little about that relationship, the relevant one. And importantly, in terms of responding to Wetherspoon's case on this appeal at 25 of their skeleton, the company number and insurance position of Risk Solutions is irrelevant in that assessment.
I mean, I think you're effectively saying this. You say what matters is the relationship between the tortfeasor and Wetherspoons, not the relationship between Risk Solutions and Wetherspoons. Were the relationship between Risk Solutions and Wetherspoons important? Well, I mean, you've got Risk Solutions, a separate legal entity carrying on its own business. So is there anything in this contract that suggests that as between Wetherspoons and Risk Solutions wasn't an independent contractor?
Possibly not. It's not the relevant question, though.
I'm not quite following
and it
that.
would be, and I
That's the
think
important
we
point.
don't need to
You
develop
say it's
that.
not the relevant question, but if it were the relevant question, this is a contract for services provided by an independent contractor.
Yes, but I would submit not a specialist. Essentially, an independent contractor is akin to an agency that supplies labour. Because as I'll go on to develop, what the evidence that we do have, and it's limited because we heard from no one from Risk Solutions about any of this, but the evidence that we do have is that all Risk Solutions were doing was supplying labour. They weren't doing any management on the ground, and they weren't doing any relevant training, save for a walkthrough. There was some evidence that a walkthrough at the start of each shift was done by a risk employee rather than Wetherspoon's. Sorry, the start of each member of staff's placement with Wetherspoon's.
Am I getting that wrong? I had in mind there wasn't really much evidence of Wetherspoon's doing any training at all.
Well, this is. I'm at risk of. Perhaps I can come back.
Yes, sorry. So come back.
Because
To it.
we're at risk of coming
Yeah.
off topic. Because the main point that I think I wanted to highlight. This is. I'm responding to paragraph 25 of my letter from Skeleton, where they set out the reasons why they say the contract's clear. Our first point is that their reliance on Risk Solutions, insurance position, and company number is irrelevant because that's not the relevant relationship. And I think that point is understood, and if it is, I'll move on to what is my second point, which is that their reliance on clauses 3.7 and 3.8, which again that's in the supplemental bundle at page 10. Well, this is where it's asserted by these two parties to this contract that Risk will retain control and Wetherspoons will not acquire it. But those assertions, and that's all they are in tension with other provisions of this contract. And this is where the lack of clarity arises, even on the face of this document, even if the court is, which we don't accept, confined to it. For example, if I can ask my laws to turn to page 25 of the supplemental one, page 20 of the contract. And here we have the schedule setting out the standard of service, which Ms. Malkai referred to was present, something similar to this was present in Hawley. And if we look at paragraph 2, and we can see the final words of that introductory sentence, that these are rules of behaviour set by Wetherspoons for these guards.
Well, they're set by the contract for the guards.
Yes, but they are, we would submit, it's Wetherspoons dictating here how it would like detailed aspects of the job to be done when working there.
I mean, the judge says, paragraph 92, that he accepts your submission, that Schedule 1 is the more important part of the contract, which sets out how Risk Solutions is supposed to do what it's to do, and that constitutes and demonstrates a level of control. Well, how does it? I mean, it says that when the staff are supposed to comply with certain requirements, but where's the control?
Well, is my lord's, I take from my lord's question is the concern that it's set by the contract and it's not necessarily Wetherspoons the one setting the rules, or is it that?
Well, I suppose, I mean,
or is it both?
you've got to, I mean, this isn't an unusual sort of contract. You find a contract saying that the contractor is supposed to behave in a certain way. But when you talk about control, you'd think somebody on the ground must be entitled to tell their people what to do. Is there anything in Schedule 3 that has Wetherspoons being able to tell their people what to do?
Yes. If we look at over the page, on page 26 of the supplemental bundle, we can see item L, the final item on this list, and you can see some pictures there indicating acceptable approaches to restraint, and you can see that this rule of behaviour is confirm agreement to the JDW, the Wetherspoons policy on restraints and holds. Mm-hmm. there's then a detailed set of rules about what types of restraint are acceptable and what aren't. And it's easy to look at this and think, well, this is just a minor aspect of the role. But when one stands back and thinks about what a security guard does, they're there to keep the peace. They're there to maintain security at the pub. They're largely observing. I mean, this is just one's general knowledge, having been in pubs with security guards, as I'm sure everyone has been at some stage. They're generally observing, and when things become difficult, they are becoming physical with the people in the bar, and they're removing them. And this aspect of the role of the security staff is, we would submit, the only aspect of this role that is in any way specialist. And as Lady Justice Hallett observed in Hawley, it's not even particularly specialist. And we can see that this, what I would submit, is the core of the role of these, this supplied labour under this contract. It's to be done in accordance with Wetherspoon's policy, not a policy set by the contract, which is neutral between the parties, not one set by Risk Solutions, who, under clause 3.7, 3.8, are the ones alleged to have control. And the only point I seek to draw from this for present purposes is that, because in fact control wasn't ultimately incredibly relevant to even the recorder's finding, and the authorities of course make clear that it's not to have independent significance. But the key point is that on Wetherspoon's case on the law, if the contract is clear, one doesn't look further. This contract isn't clear, in my submission, and that's what this shows, is that they rely on the irrelevant position of Risk Solutions, and they rely on the assertion at 3.7 and 3.8 as to who has control, but those assertions are undermined by the substance of the agreement.
I mean, you'll come on to this perhaps in more detail, but there's been the suggestion that this agreement is in conflict with what happened on the ground. Which bit of the agreement conflicts with what happened on the ground?
Well, one very important example is 3.7 and 3.8, which say that it is Risk Solutions and not Wetherspoons who are responsible for the direction, management, and control of these staff.
So to be in conflict, you've got to find Wetherspoons people telling the people on the ground what to do.
Yes. And that is exactly what the recorder found, as I will come on to say. And that's an important point in this appeal, because that was a factual finding. The judge seems, and I'll come on to develop this, to have got the impression that there was no substantial dispute of fact here. That just isn't right. On every aspect of the BXB checklist, myself and my learned friend Mr. Payne made submissions that were opposite from one another, and I can take my lords to the relevant part of the trial transcript if it would assist, or I can provide the reference now. But
it's more helpful to have the recorder's findings, really.
Yes, well, I will. Yeah. I was trying, my lord, to address the point raised.
Yeah.
And I'll now move back onto the recorder's findings. But the point is, if there was, it's not apparent necessarily from the judgment alone, or it appears that the judge didn't hoist in from the wording of the recorder's judgment that these matters were disputed, but they were. There were opposing submissions from both sides of the litigation on what findings the judge should make in every aspect of the BXB checklist, and the judge ultimately reached a landing and a finding on each one. Those were disputed issues. And what the judge did, and I will come back to this, is he substituted his own view on those matters for those of the recorder. And we say he just wasn't entitled to do that. I mean, there are other provisions, and I will, trying to sort of short circuit matters a little bit, because to keep to time. My Lord Justice Newey asked, what other provisions of this contract show or are, show Wetherspoons having control. There are other examples, and I propose just to give one more. If we go to clause 3 of the contract, because it's clearly an important point, and I want to show that it's not only Schedule 3 that does this. We can see that 3.6, for for the avoidance of doubt. And to give context, this clause point 3 is entitled, we can see from the previous page, provision of the services. So it's in my submission the core substantive clause of the contract. And when one reads it, and I don't propose to take my rules through it now because there isn't time, but I would invite my rules to read the whole thing, because what this shows in my submission when read as a whole is that this contract is all about the provision of labour. It's about provision of the staff to the premises for the duration of the term, which is undefined. It lasts until one party cancels it. And it's the provision of labour on an open-ended basis. And what we see when we go to paragraph 3.7, forgive me, 3.6, is that any failure by the security staff to perform the services in accordance with the standard of service, so that's Schedule 3, the rules of behaviour that we just looked at, Wetherspoon's admissions policy, and in accordance with the standards and conduct set by the SIA. And it's relevant to, if I can just give, because no findings were made in the judgment about this admissions policy, and it's unfortunately not in the bundle, but there is a reference to the transcript, which again, in the interest of time, I won't take my lords to, but I will just provide.
No, please don't do that, Miss Moses. I'd like to understand the case now, not when we've reserved judgment.
Okay.
You've got you showed us at page 25 skeleton argument with very helpful annotations to the transcript. So those are the submissions you're making.
Yeah.
I hope.
They are.
Tell us what the recorder found.
I see. Well, to look at that, we can go to paragraph 79 of the recorder's judgment, which is in the supplemental, the core bundle, at page 132. And I understand my lord's request is to look at what the recorder found in relation to the position on the ground. Have I understood that
Yes.
correctly? It runs from paragraph 79 to 100.
He picks up the sort of 6 points that are identified in BXB. It's
Yeah.
headings.
So it really, I mean, the first point that he picks up is really 81.
Can I ask
Where it
about
talks
that?
payment.
The Trinity system recorded the hours, and I assume that Risk Solutions then invoiced Wetherspoons according to the number of hours that the doorman had done. And I assume that Wetherspoons then paid Risk Solutions what was due under the contract between them for the work done by the doorman. And I assume that Risk Solutions then paid the doorman on some basis we don't know about for the work that they had done. Paragraph 82, the judge says that you submitted that what really came out of the evidence was that the second defendant, Risk Solutions, was the entity that was responsible for counting the hours, yes, and the payment was then made through that system. Well, the payment was made to Risk Solutions through that system. Does it go any further than that?
Well, one point I do want to pick up is this, one of my lord's assumptions that Risk Solutions issued an invoice, because there was some discussion about this.
Well, perhaps forget about the invoice. The fact is, there's a contract between Wetherspoons and Risk Solutions under which so much is paid per hour for the hours that the doormen do. That's a perfectly understandable contractual relationship between Wetherspoons and Risk Solutions. We don't know how that related to what the doormen were paid by Risk Solutions, but presumably Wetherspoons did not pay Risk Solutions. Is there any evidence that... No.
The evidence was that the Trinity system, which was a Wetherspoon system, was used to keep a record of the hours worked. That system then produced essentially an invoice that Wetherspoon sent to Risk Solutions. saying, this is what we'll pay you and here it is. And there was evidence to suggest that there were line items for each member of staff, and there was a lot of confusion in the evidence about whether it was a global payment or individual. It was a global payment. That was the evidence that was given.
And it really doesn't matter because we can see from the contract that so much was payable per hour. So Risk Solutions needed to know how many hours the people had worked because that was what they were entitled to be paid.
Yes.
But that doesn't mean that Wetherspoons were paying the doorman.
And that's not suggested by us. It's not. It wasn't the evidence. I hope I've not given that impression that that's our case, because it isn't. It was the evidence was clear that the payment went from Wetherspoons to Risk Solutions. But the key point that was submitted to the judge, and that in my submission we can see that the judge found, is that this was essentially a payroll function, which is one typically done by an employer.
Well, I
This
saw
was
it.
not done by Risk Solutions.
I
They
saw
weren't
it-
applying any thinking to this.
I saw in the submissions a suggestion that Wetherspoons had the sort of HR function, but they didn't, did they?
Well, payroll.
They had.
I do maintain that what this is, if we look at, these are two organisations, we're looking at 3.7 and 3.8 of the contract, saying one has control, the other doesn't, one has management, the other doesn't, one has direction, the other doesn't. Well, this is management. This is who keeps a tally on their hours, who thinks about what they're paid and does all the processing that needs to go on behind the scenes to get that done, who produces the document setting it out. Well, that was actually Wetherspoons. Yes, Wetherspoons then sent a payment to Risk Solutions, and Risk Solutions were the ones that paid the staff, like an agency would.
And we don't know how much the staff are
We
paid.
don't, and I would submit it's not relevant. But the submission that I made, and my lord, I don't propose to take you to the transcript. We wouldn't have time, and it's also not appropriate, as my lord Justice Beale indicated. It's the judge's findings that matter, and that's what we criticise the judge for, is for going to the transcripts when he shouldn't have. But the key point is, and this is all the references are set out in our skeleton at 11A, where we deal with the payment points. And I would encourage my lords to read those references and to see what was said in the evidence, what was submitted to the judge, and what he found. Because, of course, what my lords have to also bear in mind, I would submit, is that this was an ex-tempore judgment given at the end of a 3-day trial in a claim of valued at around £60,000 in the county court. So the judge, the recorder, was answering, as I say, those competing submissions that were made on each item of the checklist. And I would submit, in all respects, his findings are clear. But if there's doubt about that, it is helpful in my submission to go back and look at what those competing submissions were, particularly where, as in this case, he says that he has accepted one of them. And the submission that I made to him, and which is shown in the transcript reference given at paragraph 11A of our skeleton, was essentially this point, that it was a payroll function, and that this payment system was like everything else in this case, where if you look at the substance, the position painted was that Wetherspoons was the one managing, directing, and controlling. And then there's a detail that it didn't need to happen. No one can explain why it happened. And it's one that would potentially point away from what you would expect to see in an employment situation, but it didn't affect the substance of what was observed. And that's the submission that was made. And as I say, my lords, the references are there, and there'll be those points will be apparent from the transcript if they are read.
I know you're running out of time. Can I just try another one? 86 uniform is relatively clear from the terms of the contract. So we're back to the contract. That it was Wetherspoons that was able to specify control what attire the security guards were to wear. So that must be in the contract. Where is it in the contract?
This is in Schedule 3, I believe, which would be supplemental bundle.
says in 2H, dress smartly in cute, clean uniforms.
Page 22.
And K, they've got to have an SIA badge.
There are a number of references to it. There's one on page 22, which is within Schedule 1. And it's item E in that list. At all times, dresses smartly, wears at all times a visible original SIA badge, black tailored trousers, black shoes. It's specifying a lot of detail, and the submission I would make on this point is that this is the sort of detail that you would expect to see in an employment contract. And similarly for the matters in Schedule 3.2 about chewing gum and not using one's mobile phone. These aren't the types of provisions that you would expect to see in a contract for the supply of a specialist service from a specialised professional. And these are all the qualities in my submission that appear in the cases on independent contractors. I am now coming to the end of the time that we had budgeted to spend on these issues. My Lord Justice Bean had asked to be taken to the Recorder's findings. They're set out in the judgment there. Would it assist for me to go through each one? I would submit that perhaps the better way is that all of those findings and what we say in relation to each one is set out at 11 and 42 of our skeleton.
Yes.
And
That's why I wanted to discourage you from going to the transcript to support what you've helpfully set out in those sub-paragraphs.
yeah.
When Lord Phelps and or Mr. Payne come to respond, they will no doubt tell us if something in your paragraph 11 is misstated as a matter of fact. Otherwise, we'll assume that that is indeed what the Recorder found. They may say, as a matter of law, it gets you nowhere. That's a different point. But the accuracy of what you say the Recorder found, I think, can be taken from paragraph 11 unless we're persuaded otherwise.
Yes. Well,
Can I
that's helpful.
can I just at one point of detail before we leave this? Paragraph 90
Yes.
of the Recorder. They've worked at the pub for a number of years and they continue to do so. Mr. Hager rose to the position of head door staff. Can I just be clear? The position of head door staff is that of Wetherspoon's position or a Risk Solutions position?
Well, it's a good question. We would say, and potentially a contentious one. But the evidence that came out on hierarchy was that immediately above what were referred to in submissions, I'm not sure helpfully, but this is how they're referred to as the level of staff that would be the sort of squaddies, the soldiers, if you were using army analogies, is that you had kitchen, bar and door, and you had the masses, the squaddies, and then you had a leader at the top of each group, and above them sat the duty manager.
So is he the leader of the doorman team?
Yes.
Yes.
And in fact, the whole of the doorman team, they are all supplied under this contract in an indistinguishable way. And then a decision is made, once the supply of labour is made, decision is made at the pub as to who is head. And there's reference in the witness statements to one of the tortfeasors in this case, Mr. Hager, who's currently, or left to join the police, was promoted to head doorman after the incident in which our client was attacked. And that was done at the pub. So I heard my learned friend say just now, whispering to my right, that it was a risk position. I wouldn't accept that. This wasn't something that was expressly debated or discussed or submitted on before the Recorder. It wasn't something that he found. But the evidence, as I would submit, that came out, and again, if a reference is required, but I assume it's not, because it will all be covered in the matters and the references given at paragraph 11, was that this was essentially a promotion that happened at the pub. It wasn't that Risk Solutions were sending, here's your head doorman and here are your squadrons. That's not how
Was there a dispute as to whose decision it was that Mr. Hager should be?
My recollection didn't descend into that level of detail, but there is reference in witness statements to the tortfeasor Mr. Hager being promoted to head doorman after the incident. And if one takes that, that's from a Wetherspoon's pub manager that you're getting that information. And there's nothing to suggest that Risk Solutions had any involvement whatsoever in that process. We are now at the stage where I've taken you through the contract, and my second point was going to be, and I was going to develop this in a little more detail than I now have time to do, but the core point is that if you, and I hope I've said, at least my submissions have made sense as to why we say that the contract itself under my first submission is not clear. It doesn't show a clear independent contract relationship in the relevant sense. That is what the court says. And the second point is that if one does stray outside the four corners of the contract, that the position becomes an awful lot clearer, because that paints a picture in my submission of a relationship that is akin to employment. And really I rely on all the oral evidence that we cite and the transcript reference that we give at paragraph 11 of our skeleton. So that's where it came from, the witness evidence. And there's a document that I wish just to take you to, my lords. It's in the supplemental bundle at page 3. And this is a Wetherspoon's document. And it's a Wetherspoon's document entitled Managing Door Supervisors. So this perhaps does give a clue as to whether the position outside the contract and on the ground differed from 3.7 and 3.8 as I submitted that it did. And what I would submit is, if my lords go through this document, and this was submitted to the recorder, is that it shows at every stage reporting into the duty manager, and that's a Wetherspoon's employee. We can see that in a number of the steps. Step 1, step 3, we can see that at step 4, we can see that at step 6, we can see it at step 8. Things like if drugs are found on the premises, they go to the duty manager, they don't go to the head doorman. And that is the Wetherspoon's employee who sits above all those teams of squaddies that I just outlined, kitchen, bar and door. And the evidence that came out before the recorder, and what the recorder found, was that there was no difference in practice in the reality day-to-day running of this pub as to how those three teams reported into the duty manager. And what it also shows is that Wetherspoon's was controlling and directing every aspect of how these staff did their job. And on Wetherspoon's case, this presumably is impermissible because it goes outside the four corners of the contract, and we say that that can't be right. My third point, in addition to the importance of the oral evidence, there were credibility findings by the reporter, and those can be found in his judgment at paragraphs 17 to 21. That's in the core bundle at page 125. And I invite my lords to turn it up. And what we can see there is that the recorder found the witnesses to be variously defensive, unhelpful, more concerned with protecting their employer than answering the questions given by the court. The greatest criticism was levelled by the judge, by the recorder with me, at Mr. Murphy, who is the most senior of the three employees, and he is a general manager employed at Wetherspoon's head office, and he is in charge of overseeing the running of 180 of Wetherspoon's 800 or so pubs, and he sits on a Wetherspoon's-wide committee that is charged with management of security at these pubs. And he was the most unhelpful witness or so the recorder found. And the point that I want to draw out is that the judge, not only was the judge not willing to defer to the recorder on factual findings, the specific findings at 81 and the following of his judgment in relation to the XB checklist, which we do say, for the reasons I have outlined, were disputed issues based heavily on the answers given in cross-examination. Not only was the judge unwilling to defer to the recorder on that, but he was also unwilling to defer to the recorder on issues of credibility, and we can see that from his judgment at paragraphs 46 to 48. That's in the core bundle at 71 to 73. And what the judge did there is that he took the view that there was no real challenge to the evidence, which, as I've already outlined, we don't accept, and no real disputed facts, we don't accept that. And the cross-examination of these witnesses.
To be fair, I'm not sure he goes quite that far, does he? It may come to the same thing, but he says in 48, he thinks that the statements weren't departed from or challenged in the respects that he's quoted. Are those the points on which they were challenged?
Yeah, well, I mean, there's 2 points we make, and that's right, I accept that. But he makes a general submission that there was that the general character of the cross-examination of these witnesses was by way of assertion, and those assertions were rejected. But in my submission, he misses the point, because what he's saying is he's both saying there was no challenge to the paragraphs I've quoted. The first point that I do wish to emphasise as a side point is that the judge really shouldn't have been quoting directly from the witness statements at all, or the transcripts, because the findings were as found by the judge, and they weren't the subject of any ground of appeal before him. But having done that, he seems to have been taking into account that he did not observe any challenge to those passages, but there are challenges to other passages not quoted by him. One example is Mr. Murphy's statement at paragraph 5, which was challenged. We can see that it's the transcript reference, but it's the supplemental bundle at page 183. And if I can ask you to turn it up. And that's in the middle of the page, just above Mr. Recorder Shepherd. It may be that I've got an incorrect reference, and perhaps I can come back to this, but the point is that
there is a reference to paragraph 5. I don't know if that's the one that matters.
It's the correct one. Yes, this is the correct reference, actually. It's where paragraph 5 of his statement, you can see, if my lords note this page, but what it's showing is that at paragraph 5 of his statement, Mr. Murphy said that Wetherspoons did not control how the staff did their job, and it was put to him that that is not correct and it's not a credible statement, and that was a challenge to paragraph 5 of his statement. And so this is also a passage not quoted by the judge in paragraphs 46 and 47 of his judgment. But the more important point is that the judge missed an important point about how the evidence came out. It wasn't only that there were challenges to paragraphs of the witness statements, it was that there was a whole host of issues that came out in cross-examination that weren't covered in the witness statements, on which the judge based his findings. And in our submission, the recorder rather based his findings. In our submission, the judge, in reaching the decision that he did, overrode many of those findings, and that was not open to him in our submission to do it. Unless I can assist further, those are my submissions in the evidence.
Thank you very much.
I'm going to need to leave a few minutes for reply, so I'm not going to deal with my third section. You have my arguments on the law and why we say the recorder.
Yes, we'll break off. We'll break off now. We don't require to be taken through Volpe and all that. We know about that.
No, I appreciate that.
Right. Shall we return 5 to 2? 5 to 2. Yes.